Hello, what's up everyone? Tonight I'll be talking about professional negligence. However, since my finals dia tak adalah only masuk professional negligence, but for negligence masuk professional negligence sahaja. But to answer professional negligence, I also need to revise a few subtopics under negligence itself. So I have to revise them before I go to professional negligence. So before I get to the actual meat and gritty of the video, I'll be talking about three things, which are duty of care, breach of duty of care, and also causation and also remoteness of damage. I'll cover all of that before I actually go to professional negligence, okay? So without further ado, let's go. First is duty of care and breach of duty of care. So duty of care is the legal duty to take care of someone, and as established in the case of Donohue against Stevenson, this is a landmark case in which the plaintiff developed gastroenteritis from a dead snail from a ginger beer that they had purchased at the bar, and as a result, the court developed the principle called the neighbor principle, which has two tests to establish who is a neighbor. Basically, a neighbor is someone who is so closely affected by our actions and need to be in our consideration when we are doing or omitting from something. Okay, to further understand what the neighbor principle is, the two tests that are used are the foreseeability, which means that if the damage is foreseeable, then someone must avoid it. Someone must avoid the damage if the damage is foreseeable. And secondly, the proximity test, which means that foreseeability concerns the act or omission due to a possibility of damage. However, proximity concerns the people who are affected by our act. So proximity test is basically people who are so closely affected by our act or omission that we have to have them in our contemplation and our thought process before doing something or omitting from something. Okay, and fun fact, it's not a fun fact, it's actually an additional fact. I just wanted to say that fun fact, neighbors do not need to be identified. So in the case of Donohue against Stevenson, going back to the Donohue Stevenson case, the neighbors should not necessarily be identified, because the principle here is that as the seller of the drink, the defendant must have duty of care onto neighbors which are his potential buyers. So if he needs to keep track of every single buyer, every single customer of his drink, then it will be impossible lah senang cerita. So neighbors shouldn't be need to be identified pun to qualify as a neighbor. Okay, and duty of care arises when one party relies on another to exercise his duty of care, his degree of care. So when there is a relationship, there is a dynamic in the relationship whereby party A relies on the expertise or the care of B, then there is a duty of care on behalf of B to take care of A. Macam tu. And this was established in the case of Hadley Byrne and Co. Limited against Heller and Partners Limited, 1964. Okay, moving on to the development. What is the development after the Donohue case and after the neighbor principle case? Well, after the Donohue case, there is actually one case that established another more restrictive approach to putting duty of care onto someone, which was in the case of Caparo against Dickman. And in this case there were inaccurate accounts that were given. Accounts tu macam penyata that were given from the defendant onto defendant ni adalah satu, if I'm not mistaken, it's a bank or something that is concerned with money lah, sebenarnya monetary institution, and then they gave inaccurate advice onto their clients. Okay, and then in this case, the court established the Caparo threefold test, okay, which was named after the case lah. And this test has three components. These three are more restrictive and also more strict compared to the the neighbor principle in Donohue case, which are the foreseeability of damages, same as yang tadi tu, the proximity of damages, same as yang tadi tu, same as the foreseeability and also proximity test of the Donohue case. However, the third and defining characteristic, defining principle in the Caparo threefold test is it fair, just and reasonable to impose duty of care onto someone. Okay, so this is the defining factor that distinguishes Caparo and also the neighbor principle. Okay, so this test was used in the case of Loh Kwan Moy and others against Ramli bin Jamil and government of Malaysia. So in this case, on Chinese New Year, there was a raid done onto boats that was at some ferry or something lah, jetty or something. And then the police went for the raid, and some of the men who were in a particular boat jumped into the river, and the police shouted to them to get up, to get back onto the boat, to be arrested lah senang cerita. So a lot of them got up to the boat, but there was one of the many men who jumped into the water who was clearly struggling to stay afloat. And there was a boat passing by that in that boat, one of the crew members of that boat wanted to help, but the police said, kalau kau tolong dia, kiranya kau bersubahat. That's it. So that made the person who wanted to help be deterred lah by the police's shouting, and as a result, the person who was struggling in the water died. And then the issue is, was it just fair, just and reasonable to impose duty of care onto the police for saying that statement? So the court held that yes, there was duty of care onto the policeman for having shouted such claims, even though he clearly knew that that person who drowned had difficulties in the water. Okay, that's it for duty of care. Now we're moving on to breach. Breach is very simple. So to determine breach, okay, actually it's not that brief pun. It's just that I only used the principle that I need to use in my exam, so I won't be covering much. I will be covering like only 2 points. So to determine a breach of duty, the court needs to consider 2 things. First, the court must consider the standard of care that is required onto the plaintiff, and second, whether on the balance of probabilities the defendant has failed to meet that standard of care as required by the court. Macam tu. We're actually done with duty of care and also breach. Now we're moving on to causation and also remoteness. So causation is what are the causes that can, macam mana cakap? Causation adalah punca lah, senang cerita, punca. Okay, so there are 3 types of causes. First is single cause, second is multiple causes, and third is successive causes. Okay, so disebabkan the definition of causes itself is punca, so single cause adalah singular punca lah, senang cerita kan. Okay, sabar. Okay, generally for causation of damages, we use the but-for test. The but-for test states that, but for the negligence, okay, sabar. The sentence itself is a bit complicated, so I'm just gonna simplify it. Okay, but-for test is basically asking the question, if the defendant had breached his duty of care, would the plaintiff still sustain his injuries? So the answer is only 2. Either yes or no. So if the answer is yes, meaning to say if the defendant breached his duty of care, then the plaintiff would have suffered damages, then the defendant would be liable. However, if it's no, that is to say, if the defendant, even if the defendant didn't breach his duty of care, the plaintiff would suffer damages, then the defendant would not be liable, because even if he did not breach his duty, the plaintiff still suffer damages. Therefore, what duty has he broken? Macam tu lah. Okay, so there are 3 types of causation yang tadi tu. First is single cause. Single cause is satu-satunya, the only cause of the damage is from the defendant's negligence. So we use the but-for test here, and this can be seen in the case of Barnett against Chelsea and Kensington Hospital Management Committee, whereby the doctor's negligence did not cause the patient's death, because in this case, if I'm not mistaken lah, dia macam something, this particular family had a private doctor, and then on one day something happened to one of the family members, and then they brought that family member to the family doctor, the doctor said, you need to refer to the other hospital, I cannot help you now. So as a result, the family member died, and then the court held that okay, the family member did contact something on that day, but it wasn't because of the doctor's negligence yang menyebabkan orang tu mati. Senang cerita, kalau doktor tu dah tolong pun, that person would still die. Macam tu. So that was why the doctor wasn't held liable. Okay. Secondly, multiple causes. For multiple causes, meaning to say there are more than 1, 2, 3 and above, banyak causes, the plaintiff must prove that the defendant caused or had significantly contributed to the harm that is suffered by the plaintiff. So that's self-explanatory lah. So this is seen in the case of McGee against National Gold Board. So in this case, the plaintiff was working, I think it's like a construction place lah, if I'm not mistaken. And then that construction place, because they were dealing with bricks and batu semua tu kan, a lot of dust stuck onto his body. And then the defendant, which was the employer to the plaintiff, they failed to provide a sanitation station lah, senang cerita, macam tempat untuk mandi, bersihkan badan, because when dust sticks onto your body, you might get skin irritation, right? So the defendant failed to provide any facilities for them to clean themselves, and then the plaintiff contacted dermatitis, and then the court held that yes, even though the punca asal ni adalah daripada the dust itself, but since the defendant did not provide any cleaning facilities, then the defendant was the one held liable because they failed to prevent any kesakitan that might arise from the dust and all. Macam tu. Okay. Third and the last causation is successive causes. So the successive causes, meaning to say successive is one thing leads to another. So it's like a domino effect of causes lah, macam tu. Okay, for this, the court have to determine whether each one of those causes have brought damages to the plaintiff. Okay, so this senang cerita can be seen in the case of Performance Cars Limited against Abraham, whereby there was a car that had been brought to a mechanic or a spray painter lah, senang cerita, because they need to respray some parts of the car. Okay, because of senang cerita, okay, ada satu kereta ni dia terlanggar kereta lain, and then as a result they need to respray some parts of the car. Okay, but before they had the opportunity to respray the car, repaint the car, another collision happened with another car. So there are two collisions, both of which chipped a part of the car's paint, and the plaintiff brought an action towards the defendant, which was the owner of the second car's collision, and then he said that okay, I have a part of my car that needs to be resprayed, but since you collided with my car, which made the damage even worse, then you need to pay for it. Macam tu. However, the court said that even if the defendant had made the situation worse, but he did not cause the original cause. Macam tu. Sebab dia ada dua collision kan, he only caused the second one, he didn't cause the first one. So the defendant was not held liable because he did not contribute to the first cause itself. Macam tu. Next, we're moving on to remoteness of damage. So remoteness of damage basically asks, is the damage too remote ataupun too unpredictable for any action to be brought? Okay, so the general principle is the defendant is only liable if any damage is reasonably foreseeable. So there are actually two tests to assess whether or not a damage is foreseeable. However, I'm only going to mention one because the other one was considered as bad law in the olden times. So it's more suitable to use the test that is never mentioned to be bad law. So the test is called the reasonable foresight test, in which there are two components to this test. First, the damage must be foreseeable from the defendant's conduct, And then secondly, the type of damage must also be foreseeable. So first, the damage itself must be foreseeable. Second, the type must also be foreseeable. So it is fair to the defendant lah sebenarnya. Okay. So in the case of Government of Malaysia against Jumaat bin Mahmud, this is the case where one of the masa tu, okay, it's in the classroom tau. It's in the classroom, and then someone cucuk badan, okay, seorang budak ni cucuk badan seorang budak lain, and then that budak yang kena cucuk tu dia pandang belakang macam dia nak tahulah siapa cucuk dia kan. And then masa dia toleh tu, mata dia tercucuk dengan pensel, and then as a result budak tu hilang sebelah mata. So the case was brought to court, and then the issue was whether or not the damage was foreseeable, as if the teacher who was in the classroom had larger supervision, had better supervision. So the court held that it was not foreseeable because he could not have predicted that to have happened, even if he had macam exercise proper vigilance or proper supervision onto the kids in the classroom. So this is distinguished, however, with the case of Muhammad Raihan bin Ibrahim against Government of Malaysia, also in Malaysia, also in a school, but in this case, the teacher failed to guide the students on how to properly handle some gardening tools and materials, and as a result, the students were playing around, and then one of the students injured another students with the gardening tools, and in that case, the court held that the teacher was liable because he did not give proper guidance to the students on how to operate this gardening tools. Okay, macam tu. Okay, now we're gonna briefly touch on the eggshell skull rule, which states that the defendant must take people as they are. Basically, the eggshell skull rule, okay, bayangkan someone with a very thin skull, someone who is prone to injuries lah senang cerita. If I take him as a client, as someone who I have duty of care onto, I need to take him as he is. That is to say, I need to take him with his conditions as my client. Because, yes, not many people have thin skulls, not many people are prone to injuries. However, just because not many people are in that particular condition doesn't mean that I am free from any liabilities if something happens to them based on my negligence. Macam tu. Contoh paling senang. Okay, if someone is prone to having their bones broken, macam kalau ada someone tu mungkin dia tak cukup kalsium, so dia punya tulang dia senang patah, and I take him as a football player lah sebenarnya cerita. I'm a coach and he's a football player under me, and for some reason I breached my duty of care. I was negligent in some parts, and then he suffered injuries, contoh tangan dia patah kan. I am still liable because even though he has pre-existing medical conditions, it's my duty of care to take care of him. Macam tu. So this can be seen in the case of Smith against Lichbrain and Co. Limited, where in that case the plaintiff had terkena a molten metal on his lip, and that plaintiff was prone to having cancerous cells being developed, and as a result of the molten metal touching his lip, he did contact cancer, and so the defendant was liable because they need to have a duty of care onto the plaintiff. Lastly, for causation and also remoteness, intervening acts. Intervening acts is if an event happens after a breach of duty of care and can break the chain of causation, then it can be grounds for the defendant to not be liable. Okay. However, the intervening act must be reasonable and also foreseeable, and if it does not break the chain of events, then the defendant is liable. Macam tu. Senang cerita, intervening acts ni is something that happens that is independent of the breach, but it can also break the chain of causation and also make the defendant not liable. So rasanya susah sikit nak understand, so I'll give you the types of interventions lah. First, intervention through a natural event. So in the case of Karlslogi Steamship Co Limited and also Royal Norwegian Government, there were two ships that had collided with each other, and one of the ships suffered damages, but the damages was due to bad weather. So because there was intervening act from God, divine intervention, so the defendant was not held liable for part of the damages because they didn't cause it. So second is intervention by third party. So intervention of third party must be an act that is independent from the breach. Contohnya, if A happens, negligence happened in event A, and at the same time event B happened that can also break the chain of events of A, but the events that happened in B was independent and also unrelated to the events that were happening in A, cuma dia boleh break the chain of causation. That is what intervention of a third party means. Okay, so if a breach of duty of care or from someone induces the action, then the defendant is still liable. So that reinforces the fact that intervention by third party must be one that is independent of the breach itself. Okay, macam tu. Okay, this can be seen in the case of Scott against Shepherd, where in this case a lighted script is like mercun lah senang cerita. A lighted firecracker was lit and thrown into a marketplace. So that firecracker bounced a few times and it landed on a few people lah, 2 people if I'm not mistaken. So both people took the firecracker in their defenses to throw it out onto someone else. Okay, so dia sampai ke orang A ambil, dia baling, sampai ke orang B ambil, dia baling pula. So it just so landed onto the plaintiff's, I think, foot or something, and it exploded, making him blind in one eye. And then the case was brought to court, and then the defendant said that, oh, we didn't cause the plaintiff's damages because it didn't land on him, someone else threw it, and then that guy should be liable because he threw it onto the plaintiff. But the actions of A and B yang baling tadi were to defend themselves. They did not intend to cause any damage pun. They were just trying to defend themselves. Macam tu. So the court held that the defendant was liable because they caused the initial reaction. See what I mean when I say if the breach induces action. So if the breach induces action, meaning it induces someone else to act, then the defendant would still be liable. Okay. Thirdly is the intervening act of the plaintiff. So intervening act of the plaintiff is basically when even though the defendant had negligently breached their duty of care, but the defendant also did something that contributed to his damages, his injuries, then that is intervening act of the plaintiff. This is considered as contributory negligence. This is the term lah, contributory negligence, and that's it. Okay, this is seen in the case of Haris Aiman against Berjaya Times Square Management Sendirian Berhad and another, where the plaintiff tak tahan kencing and then he was looking for a restroom. Dia buka pintu, dia ingatkan this particular door led to the bathroom, and that door ada signboard saluran exhaust dapur. So he opened it and he was at the 7th floor, dan dia terjatuh sampailah first floor macam tu. So I can't remember where the negligence was, but since the plaintiff himself saw the signage, still chose to open it, knowing full well that it wasn't a restroom, that was a contributory negligence on the plaintiff's part. Okay, macam tu. Finally, we're getting into professional negligence. Okay, professional negligence is very simple, very singkat je, kat sini je. First, we need to define what is a professional. So, professionals are persons who have acquired special knowledge or skills, and basically professional negligence is the breach of professional duty towards their clients. So to assess whether or not someone has breached their professional duty, we will use the Bolam test, which is introduced in the case of Bolam against Freyern Hospital Management Committee 1957. In this case, the plaintiff had to undergo electroconvulsive therapy, and the defendants had to harness some sort of safety mechanism onto the plaintiff so that he wouldn't have suffered any injuries, contoh broken bones or something, because back in the day medical treatments were quite harsh kan, as we know. So the defendant failed to provide any safety harnesses for the plaintiff's therapy, and as a result the plaintiff suffered damages. If I'm not mistaken, he broke his jaw or something, and yeah, that was the start of the Bolam test. The Bolam test basically states that a person with skill must exercise the skill of an ordinary competent human being in the same profession. So in the Bolam case, since the defendant were doctors, they had to exercise the duty of care and also the standard of care that other doctors are exercising, and since they didn't, they were held liable. Macam tu. However, professionals, contoh doctors are not required to exercise the highest degree of skill such as specialists, because specialists themselves are in their own league, so to say. Specialists are compared to other specialists, while professionals are compared to other professionals because their skill levels aren't the same. Okay. However, the Bolam test isn't the only test that is used to consider professional negligence, because in the Commonwealth countries, this is a progression in the development of professional negligence. In the case of Rogers against Whittaker, the appellant failed to warn the respondent of the possibility of developing a condition as a result of their treatment, and the appeal was dismissed. Okay, senang cerita, the principle in the case of Rogers against Whittaker is that professional duty of care extends to the duty of informing clients about possibilities and also advising them of the possible dangers of their actions, because failure for them to warn or to inform their clients of the possible damages, possible harm as a result of their clients' actions, if they fail to do that, then the client would not have anticipated any damage, any injury. So if you inform them of the possibilities of what could go wrong based on their actions, they might have changed their mind. Contoh, aku rasa aku explain panjang sangat, so aku bagi contoh lah. Contoh, if I'm a doctor, I have to treat my patient with something that I know could have negative repercussions. I tak apa. Okay, so if I'm a doctor and I advise my clients to undergo a particular therapy which I know could have negative consequences, I have the duty to warn my client on the possible negative consequences, because that could be the reason why my client would choose not to go through with that treatment. Macam tu. That is the principle basically of the case of Rogers against Whittaker. Okay, in Malaysia, we applied both principles into our cases. For example, in the Bolam test was used in the case of Chin Kiao against Government of Malaysia. However, in the case of Rogers against Whittaker, it was used in the case of Fu Fiona against Dr. Su Fuk Moon, because the issue was whether the practitioner's duty extends to informing patients of risks of treatment. So that was the issue, and the issue really is really aligned with the principles established in the case of Rogers against Whittaker, right? So the court used the Rogers principle, which was more accurate in that particular case. So in Malaysia, we adapt both principles and we use them to the cases which we deem fit. Macam tu. And I think that's about it. Yeah, that's about it. I finished duty of care and breach, also causation and remoteness, and also professional negligence. Okay, that's about it. See ya.